Welcome to Mayor Brown's Global Financial Markets Podcast. Each 30-minute episode is designed to help listeners better understand the legal issues that impact their business given the ongoing uncertainties in the financial markets worldwide. Speakers from across Mayor Brown's practices and offices provide their timely insights on a wide range of topics, including finance, financial services, and insurance regulatory developments, securitizations, and litigation in the United States, the United Kingdom, Europe, and Asia. We hope you enjoy the program.
Hello, listeners. Our topic today is CFPB proposes rule to stop new junk fees on bank accounts. My name is Frank Doorley, and I am a partner in Mayor Brown's Financial Services Regulatory and Enforcement Group in our Washington, D.C. office. Joining me today is Mayor Brown partner Christa Bieker. Christa is also a partner in our Financial Services Regulatory and Enforcement Group in our Washington, D.C. office. With that said, let's begin. We'll start by discussing the background of the government's so-called war on junk fees charged by consumer financial services providers and the regulatory efforts and rulemakings that the CFPB has undertaken to put that initiative into action. After that, Christa will discuss the legal framework and some general considerations around fees as entities seek to make sense out of the regulator's new effort against junk fees. We'll start in January 2022, when the CFPB announced an initiative to reduce what it characterized as quote-unquote junk fees charged by consumer financial services providers. And it issued a request for information for consumers to share their experience with certain fees across the consumer financial asset and product spectrum. The CFPB's request for information noted that the Bureau was concerned about fees that, in their view, far exceed the marginal cost of the service that the fees purported to cover, and whether fees were predictable and transparent to the customer or not. The CFPB articulated its concerns that certain fees can add up and, in its view, pose significant costs to consumers, especially those with lower wealth and income. It did not take long for the CFPB to take its first step towards limiting certain fees. In June of 2022, the CFPB issued an advisory opinion which stated the CFPB's view that the Federal Fair Debt Collection Practices Act, or FDCPA in shorthand, prohibits debt collectors that are subject to the FDCPA from charging convenience fees that are imposed when a borrower opts to make a payment online or by phone, unless those convenience fees are either expressly authorized by the underlying agreement that creates the debt and are not prohibited by law, or are expressly authorized by law and are not prohibited by the agreement. In September of 2022, President Biden and the White House announced their own initiative on so-called junk fees and related pricing practices. The White House's announcement defined junk fees as fees that are designed to either confuse or deceive consumers or to take advantage of lock-in or other forms of situational market power. The announcement highlighted three specific fees in the financial services and credit context where the White House alleged providers derive a significant source of revenue. These are credit card late payment fees, bank overdraft fees, and non-sufficient funds fees. On January 17, 2024, the CFPB turned its attention back to overdraft fees and issued a proposed rule that would amend Regulation E and Regulation Z to subject overdraft credit and the associated fees to the Truth in Lending Act and Regulation Z, except where the fee that's charged for paying an overdraft does not exceed the financial institution's costs and losses for paying the overdraft, or alternatively, does not exceed a benchmark fee set by the CFPB, which could be set as low as $3. Overdrafts that do not fit these parameters would be subject to Regulation Z's credit card provisions. So financial institutions that are subject to the rule would be required to underwrite the consumer's ability to repay, among other requirements. The proposed overdraft rule would apply to insured depository institutions with more than $10 billion in assets. And this proposed overdraft rule followed an October 26, 2022 Consumer Protection Circular from the CFPB that set forth the CFPB's view that imposing overdraft fees on transactions that are authorized when the customer has a positive balance, but later settle when the customer has a negative balance due to payment of other items in the interim, for example, may violate federal consumer financial laws. Overdraft fees charged in this particular circumstance were also the subject of a September 2022 CFPB consent order entered into with a financial institution.
Next, the CFPB issued a proposed rule on January 24th, 2024 that would prohibit financial institutions from charging insufficient funds fees on instantaneously and nearly instantaneously declined transactions by declaring charging these fees to be an abusive act or practice under the Dodd-Frank Act. What's unique about this rule is that the CFPB acknowledged that very few financial institutions currently charge NSF fees on these types of transactions. So unlike the other CFPB actions on junk fees, which reacted to practices that the CFPB asserted are common in the market, this rule seeks to proactively ban a fee as a prophylactic measure, even though very few market participants currently charge these fees. And most recently, the CFPB issued its highly anticipated final credit card late fee rule on March 5th. The Card Act and Regulation Z provide credit card issuers with a safe harbor to charge late fees so long as the late fees do not exceed a threshold that is annually adjusted for inflation. That safe harbor is currently set at $30 for an initial late payment and $41 for a subsequent late payment. The CFPB's final rule amends Regulation Z to lower the late fee safe harbor to $8 for an initial missed payment and ends the automatic annual inflation adjustment of the late fee safe harbor. The final rule does contain an exemption for small card issuers, which are those credit card issuers who, along with their affiliates, had fewer than 1 million open credit card accounts for the entire preceding calendar year. If an issuer with fewer than 1 million accounts in the prior calendar year meets or exceeds that number in the current year, it would cease to be a small card issuer 60 days after reaching the 1 million account mark. To wrap it all up, the CFPB has kept true to its January 2022 announcement launching its initiative against junk fees. With the proposed rule on overdraft fees, the proposed NSF fee rule, and the final rule on credit card late fees, the CFPB has now either proposed or issued rules on all three types of fees that the Bureau called out in that announcement. And given that the CFPB has targeted other fees as well, such as convenience fees, it might not be the case that the CFPB is going to stop there.
With that, I'll go ahead and hand it over to Christa.
Thanks so much, Frank. I'm going to discuss the regulators' war on these so-called junk fees from a UDAP perspective. So first, NSF fees. A significant part of the CFPB's campaign against junk fees has been focused on non-sufficient funds fees, or NSF fees. The CFPB has made it very clear that it disfavors these fees. If a financial institution doesn't cover a transaction and instead returns it unpaid because the consumer does not have sufficient funds, the financial institution may charge the consumer an NSF fee. NSF fee policies vary by institution and even by account type offered by the institution. And according to the Bureau, NSF fees are typically flat fees charged on a per transaction basis, and they average around $32. The CFPB has released several reports looking at NSF fees. According to the CFPB, banks have historically relied heavily on fees like this, NSF fees and overdraft fees, and according to the CFPB, those two fees accounted for nearly 2/3 of banks' fee revenue in 2019. The CFPB has said that the cost to the institution to return a payment is likely very low and not in proportion to the size of the NSF fee charge. Further, the CFPB has said that because all banks do is return a payment, consumers receive, quote, no service at all in exchange for the NSF fee. So the CFPB doesn't like these back-end fees. The banks advertise in large letters, free checking account, but then they make a profit by charging these more opaque overdraft fees, NSF fees that are just a little more opaque and, according to the CFPB, hinder competition. So the CFPB has been using its bully pulpit to encourage financial institutions to change their NSF fee practices. They've been releasing, public information about NSF fees that financial institutions charge in an effort to name and shame them into eliminating or decreasing these NSF fees. And while the CFPB hasn't said that charging NSF fees across the board is unlawful, it's taken the position that charging NSF fees in certain types of circumstances constitutes a UDAP. First, in January, the CFPB issued a proposed rulemaking on NSF fees relying on its abusiveness authority. Frank mentioned this. Under the proposed rule, the CFPB is looking to prohibit NSF fees on debit card transactions, ATM withdrawals, and some person-to-person payments that are declined instantaneously or near instantaneously. Typically, NSF fees are charged for return check and ACH payments. So as Frank explained, we understand and the CFPB acknowledges that the types of fees targeted by this rule are those that are charged on debit card transactions, ATM withdrawals, and person-to-person payments are rarely charged. Even though the CFPB recognizes that the fees are rarely charged, Director Chopra stated that the rule is necessary because, quote, large banks and their consultants have concocted new junk fees for fake services that cost almost nothing to deliver. The CFPB also mentioned that technological advances in the future may allow financial institutions to decline more transactions in real time, and in that case, this rule would be more impactful. Significantly, this is only the second rulemaking that the CFPB has relied on its abusiveness authority for. Under the Dodd-Frank Act, as you may know, an act or practice can be abusive for several reasons, including because it takes unreasonable advantage of a lack of understanding on the part of the consumer of the material risks, costs, or conditions of the product or service. The CFPB has explained that charging junk fees in the circumstances targeted by this rule is abusive because the consumer who would be charged an NSF fee on these transactions must lack awareness of their available account balance and lack understanding of the account's material risks, costs, or conditions at the time they initiated their transaction. Otherwise, if the CFPB thinks that the consumer knew that they would be charged this NSF fee, they would have chosen not to initiate the transaction. This is a bit of an aggressive take on their abusiveness authority, and another example of an instance in which disclosure does not cure the issue, showing that in some cases the CFPB simply thinks that simply doesn't like the fee, thinks the fee is bad, regardless of how well it's disclosed. Comments on this rule are due by March 25th, 2024. The second type of NSF fee that the CFPB has taken the position that it constitutes a UDAP is an NSF fee charged on a representment. In other words, multiple NSF fees charged on the same transaction. If a transaction is returned unpaid due to insufficient funds, the merchant might decide to represent the transaction, thinking maybe the transaction will be successful tomorrow, so they represent it. And the financial institution might charge the consumer an NSF fee each time the transaction is represented and they have insufficient funds to cover it. And so because of that, in some cases, consumers are assessed multiple NSF fees for the same transaction and kind of get caught in a cycle. And if the average NSF fee is around $30, you can see how, for example, a $50 transaction could become more than twice as expensive if you're hit with multiple NSF fees. In 2022, the FDIC and the New York Department of Financial Services released guidance indicating that charging NSF fees on representments raised unfairness concerns. But before this, the concern was mostly with deception and making sure that the NSF fees that were charged on representments were adequately disclosed, expressly and clearly explaining in account opening documents and possibly in other places that if an item is presented multiple times for payment fees may be applied after each presentment. It wasn't really until 2022 that regulators began publicly raising unfairness concerns. And although the CFPB has been making it clear for a while that they disfavor NSF fees, they didn't publicly state that charging multiple NSF fees on a single transaction may be an unfair practice until last year. In a 2023 edition of Supervisory Highlights, the CFPB explained that the assessment of multiple NSF fees for the same transaction caused substantial monetary harm to consumers, totaling millions of dollars, and that the injuries were not reasonably avoidable by consumers regardless of account opening disclosures. We and other lawyers were making the argument that the charges were reasonably avoidable if they were clearly disclosed, because the disclosures put consumers on notice that if they didn't have sufficient funds in their account, they could be assessed these fees, and consumers could make sure they kept enough money in their accounts to cover their transactions. The CFPB clearly disagreed with that analysis. Supervisory highlights doesn't really explain why the injuries are not reasonably avoidable by consumers, but I think the idea is that consumers don't have control over or involvement in the representment of transactions, and there's no way for a consumer to avoid representments once they've attempted a transaction. The CFPB directed the entities it cited in the relevant exams to refund consumers. And in the fall 2023 edition of Supervisory Highlights, the CFPB noted that to refund consumers, some financial institutions had used incomplete reports that only captured certain representment NSF fee charges, and the CFPB directed those entities to revise the remediation methodology to make it more comprehensive. Also, the Bureau stated that, quote, virtually all of the institutions it engaged with on this issue plan to eliminate NSF fees entirely. One consideration here is that eliminating all NSF fees may be procedurally simpler than eliminating just NSF fees charged on representments, because I understand that in many cases it can be difficult to know if a transaction is a representment or not. And along these lines, the CFPB has cited some core processors that banks often rely on when they're doing these transactions, and they cited the core processors for unfair practices by contributing to the assessment of these NSF fees on represented items, because the way their systems were set up made it difficult for the financial institution to kind of facilitate policies that eliminate NSF fees on representment. So that's kind of an interesting twist. Next, the CFPB has also said that it's unfair to charge consumers unanticipated overdraft fees. Frank mentioned this. These are the APSN transactions, authorized positive, settle negative. So when the consumer made the transaction, the consumer has a sufficient balance in their account to cover the transaction, but because of a delay between the authorization and the settlement, the consumer did not have sufficient funds at the time of settlement. And that disconnect, like Frank mentioned, can happen for several reasons, including the order the transactions post and kind of intervening authorizations that can result in holds on a consumer account. The CFPB has addressed this in supervisory highlights, in a circular, and in settlements, like Frank mentioned. Essentially, the Bureau thinks that the authorization and settlement process is very complex and nearly impossible for regular people to make sense of, so that even if they're watching their account balance really closely, they may not be able to figure out whether they will be charged an overdraft fee or not. And as Frank mentioned, this was the subject of a major consent order. The CFPB settled charges against a bank for what it labeled, quote, illegal surprise overdraft fees. They required $141 million in consumer redress and a $50 million civil money penalty. One kind of big strike against the bank in this case, with the CFPB said that leadership at the bank knew about this issue and could have discontinued the practice, but they didn't, because they chose to wait until the bank enacted changes that would generate new free revenue to make up for ending these APSN overdraft fees. This is the theme we see in connection with the CFPB's concern with fees. The CFPB is looking at whether these fees are just a profit center, or what is the justification for these fees. In addition to NSF fees and overdraft fees, the CFPB has scrutinized a really wide range of other fees and identified a number as UDAPs, including the following: late fees in excess of the contract amount, late fees after acceleration and repossession fees higher than average repossession cost, fees for unearned add-on products after early termination of a contract, fees that should not have been charged by law, like per the CARES Act or per HUD loss mitigation requirements, repeatedly charging consumers for unnecessary property inspections, and among others, payment processing fees that far exceeded servicers' costs for processing payments. So to conclude, I'd like to run through a list of questions entities can ask themselves from a UDAP perspective when they're considering whether or not they should charge a fee or stop charging a fee. A good first question to ask is the fee authorized by the underlying contract? Is the contract silent on the fee? Next, is the fee properly and prominently disclosed, including at account opening? This is a key deception concern, but as you know, it's not the end of the inquiry. Even properly disclosed fees can be UDAPs. Another question to ask is, does the fee far exceed the cost of the service provided? What is the fee being charged for? What is the amount of the fee based on? We know from CFPB highlights and other CFPB releases that the CFPB will expect that the company is providing, some meaningful service in exchange for the fee. Is the fee a profit center? If it is, the CFPB will scrutinize the fee more heavily. And then you should think about how you would defend against a claim of unfairness or even abusiveness. How can consumers reasonably avoid the fee? And remember here that disclosure and knowing about the fee is not enough and may not mean that the consumer can reasonably avoid it. Generally, entities should also consider whether fees are being regularly reviewed and the rationales for the fees documented. So thank you for listening. If you have any questions about today's podcast or anything else related to global financial markets, please email us at gfm@mayerbrown.com. Thanks again for listening.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayer Brown audio programming, visit mayerbrown.com/podcasts. Thanks for listening.